Let's take a look at a key case in the law of tort. This is the case of Bradford and Robinson Rentals in 1967. This is a key case for the topic of remoteness of damage within negligence. The facts of this case were as follows. The claimant was Mr. Bradford, and he was making a claim against his employers, Robinson Rentals. Mr. Bradford was instructed by his employer to undertake a long return journey in order to exchange a work van. The journey was around 450 to 500 miles and required around 20 hours driving. At the time that Mr. Bradford was instructed to undertake this task, there was extreme weather. It was unusually cold for the time of year, and the travel advice at the time was not to travel unless entirely necessary. The employer knew that neither of the vans had any heater within them, and despite the claimant taking measures such as wrapping up warm to ensure that he did not get ill, he suffered frostbite as a result of taking the journey and the extremely cold conditions. So he sought a claim in negligence against his employer for making him take the journey and the injury that he suffered. The outcome of this case was that the defendants were found to be liable, and in the judgment the court outlined the relevant principles of remoteness of damage. The court held that the principles of remoteness of damage do not require that the precise nature of the injury that the claimant suffers be foreseeable. In this case, it was foreseeable that the claimant would suffer some kind of cold-related injury. And although the extent of the injury, frostbite, is not usually to be anticipated in England, because the type and kind of injury was foreseeable, this meant that the particular damage that the claimant suffered was not regarded as too remote.